Education, Section 183. General Assembly to provide for school system. The General Assembly shall, by appropriate legislation, provide for an efficient system of common schools throughout the state. There's very little in the published debates of the Constitutional Convention of 1890 to 1891 that directly sheds light on what the delegates specifically meant by the very simple and succinct language of Section 183, which was newly introduced to the current Constitution. Most of the discussion concerned an unsuccessful attempt to amend this section to provide for a compulsory system of public education. Supporters of the amendment argued that the compulsory education was the wave of the future, while opponents contended that the proposal interfered with the rights of parents and that of farming, still the #1 occupation in the Commonwealth. It could be better, the students could be better taught on the farm or in the house than in the schoolhouse. In 1989, the Kentucky Supreme Court, in a landmark decision, held that Section 183 guaranteed the children of poorer school districts an adequate education similar to that provided in wealthier school districts, and that public education school system of Kentucky was unconstitutional because it had inadequate, underfunded in most places, and lacking in uniformity. This was Rose v. Council for Better Education Incorporated, which is important. So Rose v. Council for Better Education Incorporated is going to lead to CARA. Okay, it's going to lead to an overhaul of the government. So this is 1989. Rose v. Council for Better Education Incorporated. The court ruled that the General Assembly had a duty to provide adequate funding for all school districts and to monitor the school districts to ensure that they're providing an adequate education. This case, initiated by a non-profit corporation consisting of 66 local school districts and a number of other local school districts and public school students, constitutes another example of the state Supreme Court finding a right in the state constitution not found by the U.S. Supreme Court in the federal Constitution. So they found that in the state constitution. That Section 183, the General Assembly shall, by appropriate legislation, provide for an efficient system of common schools throughout the state. So after that decision, CARA was passed. The court's decision led not only to more uniform funding of elementary and secondary public education in Kentucky, but to more uniform tax assessment and the enactment of the Kentucky Education Reform Act. CARA. KRS 158.645 to .805. CARA represented a revolutionary and controversial overhaul of the entire system of primary and secondary public education that substantially increased the power of the state government over public education and decreased the authority of the once all-powerful local school boards. So that Frankfurt was able to interject into state school boards before. Common School Fund, what constitutes use, vote on tax for education other than for common schools. That's Section 184. I'm just reading random sections of the Kentucky Constitution by Richard M. Ireland. And then I also have this the actual Kentucky Constitution, right? Little tiny thing. And then I have this printout that I had received from, I think they get it out at Frankfurt. I don't know if there's an updated version. I saw another one online too. So the questions. Well, how many Kentucky constitutions has Kentucky had altogether? How many Kentucky total constitutions? Right now we're operating on the 1891 Constitution, which William Justice Goebel helped write, who is a German-American politician who had got assassinated in Kentucky. So that's one, 1891. That's the one that we're running on today. But how many total? And then what years? What years did those constitutions were they written? So that's the second question. How many branches of government are there? How many of the Kentucky Bill of Rights came from the 1790 Pennsylvania Constitution, Bill of Rights? So the first one, okay, so once they wrote it in 1792. 1792, there was the 27 of the 28 sections of the Kentucky Bill of Rights came from the 1790 Pennsylvania Bill of Rights. So the Constitution of Pennsylvania was integral into the construction of the first one. There was about 4 or 5 constitutions that were written. total. I'll just tell you the answer. About there's 4, legit ones, but there's a Confederate one which they had attempted to write in Bowling Green, and so I think that's actually worth mentioning because it's an attempted, like, if they would have won the war, if the Confederates would have won the war, then they would have been the legitimate, the legitimate government. And so I'm checking up on Wikipedia right now, the Kentucky Constitution. The Constitution of the Commonwealth of Kentucky is a document that governs the Commonwealth of Kentucky. It was first adopted in 1792. Oh, yeah. What is bicameral and what's the Spanish conspiracy? Those are the other questions. So, the first one was adopted in 1792. That's when actually Kentucky becomes a state. And it's been rewritten 3 times and amended many more. The latter versions were adopted in 1799, 1850, and 1891. So, those are all the answers right there. But that's okay, so it's so we could talk about each and every one of them. You got 1792 Constitution, 1799 Constitution, 1850, and the 1891 Constitution, and maybe the 1861 question mark. Okay, because each one of these constitutions are going to actually showcase problems that we have for today. So the 1792 Constitution is the first constitutional convention in Kentucky. It was called by Colonel Benjamin Logan on December 27, 1784 in Danville, Kentucky, the capital of Kentucky County, Virginia. Over the next 8 years, 10 constitutional conventions were called, each one making some progress towards a viable constitution. The state's first constitution was accepted by the United States Congress on June 1, 1792, making Kentucky the 15th state. The 1792 Constitution had several similarities to the United States Constitution in that it provided for 3 branches of government: legislative, executive, and judicial, and a bicameral legislature called the General Assembly. Bicameral it's got 2 houses, the Senate and the House of Representatives. Bicameral, there's 2 equal branches of government. They are both legislators, but they have to agree to pass any laws between the 2 of them. And so it's sort of like the House of Lords and the House of Commons. There's 38 senators in Kentucky, and then there's 100 representatives. And so that gives the Senate more elitist of appeal because one of their representatives, is only 1/38 of the power, which is actually greater than 1/100th. So the senators have more power than the representatives do, just in terms of how many there are. So that's the senators would be like the House of Lords, the elitist fucking more powerful branch, and then the General Assembly, the House of Representatives, the 100 representatives, which there's 120 counties, so that means there's 20 counties that's not getting represented, at least 20 counties not being represented in Frankfort. So the document contained a Bill of Rights and called for an electoral college to elect senators and the state's governor. Representatives were chosen by popular election. So they have a Bill of Rights, and actually the Bill of Rights I'd like to get into pretty quick because there's 26 sections in the 1891 Constitution for the Bill of Rights. And so that the great and essential principles of liberty and free government may be recognized and established, we declare that. So section 1, all men are by nature free and equal and have certain inherent and inalienable rights. Among them may be reckoned: first, the right of enjoying and defending their lives and liberties; second, the right of worshiping Almighty God according to the dictates of their consciousness; third, the right of seeking and pursuing their safety and happiness; fourth, the right of freely communicating their thoughts and opinions; fifth, the right of acquiring and protecting property; sixth, the right of assembling together in a peaceable manner for their common good, and of applying to those invested with the government of power for redress of grievances or other proper purposes by petition, address, or remonstrance; seventh, the right to bear arms in defense of themselves and of the state, subject to the power of the General Assembly to enact laws to prevent persons from carrying concealed weapons. Okay. So the right to bear arms in defense of yourself, except for concealing weapons. So if you're going to have a weapon, you have to have it posted out on top of your person, obvious that you have it. You can't hide it unless you have a carry concealed weapons card. And that all comes from Section 1 of Kentucky's Constitution. So all those rights in the first one, and there's 26 of them, and actually the 26th one basically just says that these rights supersede all the other rights, okay? So general powers subordinate to Bill of Rights. Laws contrary to thereto are void. So to guard against transgression of the high powers to which we are delegated, we declare that everything in this Bill of Rights is accepted out of the general powers of the government and shall forever remain inviolate, and all laws contrary thereto or contrary to this Constitution shall be void. So 1891, that's what they wrote in 1891. There's 26 sections total. That's Section 26. Section 1 was the right of life, liberty, worship, pursuit of safety and happiness, free speech, acquiring and protecting property, peaceful assembly, redress of grievances, and bearing arms. So that was all in the first section. You know, it took United States Constitution 2 amendments to cover, you know, the same rights that the first section of Kentucky's Bill of Rights. So automatically, that's something else I know about Kentucky's Constitution. The good things and the bad things about Kentucky's Constitution. The good thing is that they expand the rights. You have more freedoms in Kentucky's Constitution. So if we actually start looking at our own Constitution, our own state government, and see how we're supposed to be operating here ourselves, not just doing what the feds tell us what to do, if we start paying attention to our own laws, then we'll see that we have greater liberties and more freedoms. The 1891 Constitution was also written with many an anti-corporate slant, because that was the populace. They didn't like how the railroad companies and the toll roads and all the shit was coming descending upon them, the textbook monopolies. So there was a lot of anti-corporate language. Corporations are not people in Kentucky. So it expands our civil liberties, it expands our freedoms and our rights, and it also provides you know, a basis to go against the Supreme Court ruling. You know, the pro corporation, the money is speech, Citizens United decision. So my problems with Kentucky's Constitution, right? So there's two good things. It's anti-corporation, William Justice Goble, the populace. 1891 was when it was written, so there's anti-corporate slant to it. And there's more freedoms, a Bill of Rights. There's also the Section 4 is the right to revolution. So the current Kentucky Constitution legitimizes all revolution, peaceful or violent. Section 4. Okay, my problems with the current Constitution is there's many of them, because it's 1891, it's outdated, and KRS, there's so many fucking laws on the books now, it's very confusing. And it might be too confusing, and it almost might be anarchy here in Kentucky, because the people are interpreting how they want to interpret it, and so there's not an actual body of law that they're studying, but whoever's in power and however they interpret the whole fucking wealth of, you know, because there's a shit ton of laws on the books right now. There's the Constitution for Kentucky, there's the one for America, and then there's all these new laws being passed every year by the General Assembly. And then there's their own, you know, the dictates of their own moral consciousness. So if they feel as though, you know, the war on drugs is ridiculous, they don't have to prosecute any of those laws. Just like the sheriff don't have to prosecute anything that he disagrees with, especially when it comes to the federal government. So the Kentucky State Constitution, the problems that I have with it is that it's very confusing. It's not being taught in schools, and so it seems actually there's just general chaos and anarchy. The cops are the ones that just kind of hold everybody in control, because nobody really knows how this shit's supposed to work. There's no recall, there's no referendum, there's no initiative, there's no instant runoff voting, and the Democrat and the Republican Party is actually codified in Kentucky's Constitution. They have their state political parties is organized by the Constitution. So there's no recall. You can't recall governor once he's been put into office. There's no referendum or initiative, so you can't put anything on the ballot unless you get the legislator to put it on the ballot for you. But the people themselves, we have a right to petition. The very first section of our Constitution says we got a right to petition. But if we was actually get signatures from all 4 million people in Kentucky and put it to the General Assembly, unless they agree to it, there will not be a ballot initiative. And so that's really a huge hurdle that needs to be overthrown. The instant runoff voting allows for more democracy, so it doesn't tax your independent and third-party new ideas, because that's where new ideas comes from, or your independent parties. So you can vote for who you believe in without actually wasting your vote, and it can go to the person that gathers the most votes. So the instant runoff voting needs to be implemented into Kentucky's Constitution. Initiatives, referendum, and the mechanisms for recall need to be instituted into Kentucky's Constitution.